SJC-12339 in re a care and protection proceeding.
Ms. Kaiser, I appreciate your patience. Good morning.
Good morning, Your Honors. My name is Jeanne Kaiser, and I'm here with Bonnie Allen on behalf of the appellant mother. In every care and protection case in the Commonwealth, the courtroom is closed and the records are automatically impounded. These actions are taken in accord with a federal mandate to protect the privacy of the families in these cases, where the most intimate details of family life are disclosed. Here, the juvenile court judge was faced with a request from the Commonwealth and the co-defendant to remove the protection of the impoundment from this particular case. The judge had no standards by which to guide his discretion and ended up issuing a ruling that revealed every piece of paper that was involved in the care and protection proceeding. And in essence...
To the attorneys, though, correct?
That's correct, Your Honor.
Protective order?
The only order, Your Honor, so what the judge did is that he gave the parties, the Commonwealth and the co-defendant, permission to copy the file, take it back to their office, and work with the file there and inform them they needed to keep the material secret, but by the same token, just return it when they were done with the file. So in essence, what happened, now the injury to the mother would happen, the order has stayed, but the injury to the mother would happen the minute that those documents are turned over, because all of a sudden, the information that was only available to within the four walls of the care and protection proceeding is now available to a whole group of additional people. And that...
Well, when you say a whole group of additional people, you mean the father
the
and the father's attorney.
The father's attorney,
Wasn't the father and the father's attorney present at the care and protection hearing?
The father was present at the care and protection proceeding. However, the father is still bound by the rules of impoundment not to provide the records to any other party.
Any other party meaning his own attorney?
Well, I think that is true. He would have to ask for relief from impoundment in order to disclose the records of the proceedings to his attorney. That doesn't mean he can't talk to his attorney about what happened at the proceedings, but the records are impounded. He can't just turn them over to another party.
But you raised the Uniform Rules of Impoundment. They allow for release of the records, right, under certain circumstances?
Well, the Uniform Rules of Impoundment provide for the release of records if the only standard that exists in those uniform rules is under Rule 11, which says that the juvenile court can disclose if the party files an affidavit and the court issues written findings. And in most cases, requests for disclosure are very routine. For instance, if a party in a juvenile delinquency proceeding wanted an expert to take a look at the forensic evaluations in the case, they might ask for those particular documents to be disclosed. In a case like this, there needs to be a more rigorous standard applied, because here we have an entire proceeding with the testimony of numerous witnesses, including in this case psychotherapist testimony, all of the psychotherapist records, extremely personal and private information, and there needs to be some guidance to the juvenile court judge.
What standard would you suggest?
Well, Your Honor, I think, fortunately, there is an analog in the rules of criminal procedure when either the Commonwealth or a defendant is looking for third-party records. They follow Massachusetts Rule of Criminal Procedure 17 and follow the Dwyer Protocol, which was developed by this court over the course of many years for exactly the same purposes as we have here, to balance...
As you well know, those are third-party records, though. And the reason for the Dwyer Protocol is because they are third-party records under Rule 17. Here we have court records and people who testified at the C&P. It's a lot different than concerns about potential fishing expeditions and the other prongs of lamprey.
Your Honor, I don't think the concerns are really all that different, and I think that the threshold inquiry in both situations is the same. It's true that there is a difference in that in the care and protection setting, the records are in the hands of the court as opposed to the third party. But the threshold inquiry should be, when someone requests those documents, should be whether those documents are relevant, whether they have an evidentiary nature, whether they're necessary, and whether they're part of a fishing expedition. I would suggest that some of the most personal documents that are contained in the CMP file here are really, on the behalf of the parties, part of a fishing expedition. I think that's most particularly true with the mother's psychotherapist records.
Who makes that decision?
I think the juvenile court judge should take that into account. The juvenile court judge here did not. All he looked at is whether or not the mother offered the testimony in her own behalf.
What's wrong with the standard the judge applied? Judge Collins applied the standard developed by Judge McHugh in Strickland, right? The good cause standard. And what's wrong with that standard?
I think the problem with that standard is it's much too amorphous, good cause. So what the judge here thought was good cause was that broad discovery is necessary to, quote, ensure the interests of justice. That standard comes from nowhere. That's a standard that the judge decided that means good cause. The end result was...
But it tracks the impoundment standard as well, doesn't it?
Well, I don't think it really does. It is true that under Rule 7, if a party is seeking to take a case that's presumptively open to the public and wants to have it impounded, the party has to show good cause, and there's a series of factors to be considered that balance the rights of the party. The focus there is somewhat different, though, because you're seeking the opposite result. You're seeking to impound otherwise public proceedings. So the factors don't closely apply, or they don't exactly apply. But nonetheless, the factors, which takes into account the natures of the party and the controversies and the privacy rights of the individuals and constitutional rights, I would suggest are extremely close to the considerations in the Dwyer Protocol.
Then let's take the Dwyer Protocol for the sake of understanding where we are. So in Dwyer, under Commonwealth versus Lampron, when you're dealing with records that might be privileged, there's a presumptive privilege. They're presumptively privileged, and then the records come in pursuant to a protective order for the attorney, and then ultimately the stages. So here what we have is a showing that's been made to Judge Collins, and then the records are coming in to the attorneys. Now, why wouldn't it be that the trial judge, who's going to hear the case, is now with those records in camera initially, or at least in a closed hearing, taking into account concerns about the Sixth Amendment, if you can do it, make a determination that is protective of the confidentiality that you are rightly concerned with.
Well, I'm not...
So take your standard. Why isn't the standard you want to apply? Why isn't that adequate?
The standard, the Dwyer
To get
to
the
protocol, I think the Dwyer Protocol would be the appropriate standard to apply here.
You'd say the records would be turned over, at least to the attorneys under that standard, right? Because
Well, I think what happens first in the Dwyer Protocol is there needs to be a threshold showing, and that the affidavit that the parties would file would have to be far more detailed than the affidavit filed here. In this case, all the Commonwealth did is say that every record in the case was, quote, extremely relevant to their criminal case. The father merely said that, well, a lot of the witnesses are going to be the same, and it's exculpatory. But when you look, and the trial judge did not the juvenile court judge did not individually look at the records in the care and protection case and say, yes, that's true. And in the DCF testimony, for instance, that is extremely relevant, and it is likely to be the same witness.
So are you looking for a remand so that the judge does that?
Right, so that the judge, because we have to look at the records where the mother's privacy interest is the highest, and where the where neither the Commonwealth or the defendant, the co-defendant, can show that they have an interest in obtaining the documents. And again, I would say the psychotherapist's testimony is the best example of that. Neither of the parties have ever made the slightest suggestion as to why that testimony that the mother offered on her own behalf in trying to protect her constitutional right to raise her child is relevant to their criminal case.
Well, the father's heard that testimony, correct?
That's correct.
So all you'll be doing is to give him testimony that he's already heard.
He may have heard it, Your Honor, but there are two distinct differences with what happened with the court order. First of all, he may have heard the testimony, but the psychotherapist's records, all of his records associated with the mother's treatment also came into evidence. And
were therefore available to the father to review and argue at the care and protection proceeding.
that's correct. And the father, if there was relevant exculpatory evidence, just like he would have to do in a Dwyer hearing, should have said, this is not a case where it was a mystery to him. He could have made a showing, if this is not just part of a fishing expedition, if the father is not hoping to just pore over those records and see if there's something in there that maybe he can shift the blame to the mother. And he could have done that. He didn't do that. All he did was use, as if it was a magic word, the word exculpatory.
Well, I mean, essentially, he's asking for records that he's already had the opportunity to see, review, and to argue. The Commonwealth's in a different position because they have not seen or heard that testimony. So what is your position as to what should happen with regard to the Commonwealth? Put aside the father because he's already had access to them. So what should be done with regard to the Commonwealth?
Well, I would first say that I think there's a difference between access and being able to physically possess the records. But with regard to the Commonwealth has made no showing whatsoever as to why they should get these records. And additionally, if you look at the normal rules of criminal procedure, they would not be able to get the psychotherapist's records if the mother didn't put her own mental health into question. So I would say unless and until the mother were to do that, those records should not be available.
Unless it was a waiver.
Well, I think that's an important question as well, the waiver. The mother waived the evidentiary privilege that she had with the psychotherapist in order to protect her constitutional rights at the care and protection hearing. She did that because, in this case, as in most care and protection cases, the testimony of a therapist is invaluable. In almost every case, DCF will order a parent to seek treatment because oftentimes these cases, there's an underlying issue of substance abuse or mental illness or a cognitive disability. That testimony by a therapist can really help the parent show that they complied, they cooperated, they showed growth, they showed insight. Maybe the therapist has even seen the parent with the child. That provides important information for the parent. Additionally, it provides important information to the court. The juvenile court is charged with a very difficult task. It has to protect the constitutional rights of the parents in this case.
Did the mother seek to restrict the psychotherapist's testimony in any way or at this care and protection proceeding?
She did not, but I don't think that's what makes the difference here, Your Honor. She waived her privilege for the purposes of this proceeding only, and there's nothing in
On the record somewhere that she waived it only for...
Well, what's in the record is that she waived her privilege, but I think that the actual 20B, the statute that governs the confidentiality of psychotherapist testimony, says that a party has the right to waive their privilege in any proceeding. Or can assert the privilege, in any proceeding. So that means that although the mother waived her right in this proceeding, in any other proceeding, under the plain language of the statute, she would have that right to assert it again.
Under your view, the Commonwealth would have to wait to see if and when she asserted some type of responsibility or diminished capacity defense before the statute would apply and they would have access to the records?
That's exactly right, Your Honor, because there's no reason why a care and protection action should be transformed into some sort of special discovery device for the Commonwealth. This is an impounded proceeding, and it would be an ironic result if the Commonwealth were able to obtain information that they were otherwise unable to obtain.
Transcripts of the testimony.
The transcripts of the testimony, I think, should, again, be governed by the Dwyer protocol. So, for instance, and are you asking me specifically about the psychotherapist testimony?
No, just in general, testimony, the CNP from the father, mother, any of those issues.
I would like to, with my remaining time, talk a little bit about well, I see what my time is. I don't have remaining time, but can I answer that question?
That's the chief. I just work.
You may answer.
I think with regard to the testimony, the party should satisfy the Dwyer protocol, but I think special protections do need to apply to the mother's testimony because of her privilege against self-incrimination.
About the Quinn case, you're familiar with the Quinn case?
Yes.
I'm sure. In the Quinn case, the court said not entitled to have the judge accommodate both the desire to testify and the desire to remain silent.
That's correct. And what I would say is that the Quinn case really exacerbates the dilemma faced by a parent in this situation because the parent has to either exercise their constitutional right to protect their family relationship in the current protection proceeding or exercise it in the criminal proceeding. I think this court should look to its own language in so.
So Quinn is wrongly decided then?
Well, I think that Quinn involved a request for a continuance, and I think that the impoundment rules could provide special protection in a case like this, because if the court had to look at the competing concerns of a parent forced to make that impossible choice between which right they wanted to protect, and did the kind of particularized balance that this court talked about in the So case, not automatically disposing of the issue because there was a waiver, but instead considering the difficult position that the party was in and the institutional concerns of the court in making the correct decision, that in those circumstances it would be far less, the juvenile court should be far less likely to allow disclosure of a parent's testimony in circumstances like this.
Okay. One last question. With regard to the waiver of self-incrimination, is it your position that the fact that she testified at the care and protection proceeding means that she still has the ability to take the fifth at trial? Or is it your view that the fact that she testified at the care and protection proceeding means that we should treat what she said as somehow within the privilege?
I think that she clearly has the right to assert her privilege against self-incrimination at the trial. With regard to what she said, I would say that what she said remains subject to the rules of impoundment, and a juvenile court judge considering whether or not to remove impoundment of that testimony should do that particularized balance in which the court carefully considers the circumstances under which the mother gave the testimony and the concerns of the court, remembering that a parent is a central witness in a care and protection trial.
I understand, but I mean pragmatically, to the extent that the care and protection proceeding focused on whether or not the parents caused injury to the child, which I assume was the reason the state was trying to take away their parental rights, that's the same issue at trial in the criminal case.
I think it's almost certain that parts of the mother's testimony were related to that. To the degree that they were not and disclosed other personal details, I don't think that the party should be entitled to that testimony. As far as the parts that did relate to the criminal charges, again, I think the court needs to really look carefully at the need of the parties for that testimony and the circumstances under which the mother divulged it.
But even if that were true, and even if it were the Lampron standard and that was satisfied, and even if the judge at the criminal trial decided not to have all of the transcript be part of the evidence, what you would have is the mother takes the Fifth Amendment privilege against self-incrimination, she's unavailable, and the transcript comes in at trial because she's unavailable and there's former testimony with the same motive and opportunity to cross-examine. So the testimony still comes in at trial.
I'm not sure that's true, Your Honor, because under the prior recorded testimony as exception, as you stated, there has to be the same opportunity to cross-examine. And the mother, I don't know if she could be said to have had an opportunity to cross-examine herself, because usually in these prior recorded testimony cases, it's a third witness. You know, it's not the defendant, him or herself, whose testimony is the subject of the exception. It's rather a third party. So I think it would be a difficult issue in the criminal court. But I think at the very least, the juvenile court judge needs to look much more carefully than this juvenile court judge did at the considerations behind releasing the testimony. And there could be situations where that testimony would be discoverable by the Commonwealth. But I think the parties should need to meet a heightened standard, not just broad discovery ensures the interests of justice. That is far too lax a standard to release material that is as important and personal and private as this material.
All right, thank you.
Thank you.
Mr. Bluver, good morning.
Good morning, Your Honor.
Nice to see you. May it please the court. My name is Mark Bluver. I represent Christopher Conley. Before I begin, I'd like to welcome you all to Franklin County. Much appreciated. I also was asked by Clerk Keneally to let you know what we're doing here. I find myself on the unusual position of being on the same side as the Commonwealth in this case as an appellee. I'm going to argue for about 6.5, 7 minutes. Mr. Greenbaum, the same for 6.5, 7 minutes on behalf of the Commonwealth. And Mr. Chapman has reserved a couple of minutes on behalf of the child. So that is how we're set up. If I can begin, let me start with this proposition. Had Mr. Conley not been indigent and had the financial resources to retain me both in his proceeding before the juvenile court as well as the criminal court, we would not be dealing with the first issue that Justice Lenk had reserved for the court, and that being access to the record. If he had not been indigent and I was sitting in the juvenile court, I would have had access to everything, not only the testimony, I would have had access to the exhibits.
Able to use it, however? Or would
No,
you,
it would absolutely revert back to the second question that Justice Lenk reserved. But the question about whether or not, from an intellectual point of view, that I thought that information in that proceeding was either exculpatory or, within the language of Lampron, was material and relevant in the sense that it impacted an issue that the Commonwealth would have to prove going forward in the criminal trial, I would have all that information. So for me, unless this court was going to say, well, there ought to be a different standard for those who are indigent and those with means, which, given some of the decisions that have come recently out of this court, I find that very unlikely. I'd like to move, if you would, to the question of use, because I think Judge Collins was correct. I thought he was frankly too limiting when he said that in response to my motion, I couldn't have access to the GAL report or to the court investigator's report. All of that information, had I been Mr. Conley's counsel in that case, I would have had access to. So the question then becomes, as I analyze that material, as I think about that material, I think about the allegations that the Commonwealth have made against Mr. Conley in the criminal case. I think I switched into what Justice Lenk had hinted as the proper protocol would be the Dwyer protocol, that I would look at this material, make a determination in the first instance, as this court had said, it's for the defense lawyer really, primarily to determine if any of that information would be relevant for the defense.
So you think the Dwyer protocol is correct, not the Strickland protocol?
I'm beyond the Strickland protocol, if I could, Justice Kafker. I think the issue of use is really determined by the fact, I'm sorry, the question of access is really determined because had I represented him, and indeed in this case, there's a tension which I referenced in my papers. Attorney Nathaniel Tripp, who's sitting at the counsel table in the second row, he was Mr. Conley's court-appointed lawyer in the juvenile court. When that proceeding ended, I asked permission of Deputy General Counsel at CPCS if I could bring Mr. Tripp in as part of the defense team. And I received permission. He consented. But he feels his hands have been somewhat tied because of some of the ambiguity that brings us really here today. He has not been a full participant in the criminal defense team. And I think that one of the things I'd like to see coming out of this hearing this morning is an order that makes it quite clear that in terms of access to all of the material, the defense is entitled to that access. And then
Under which standard, the Dwyer? Or, I'm confused.
well, Justice Collins recognized it as a good cause standard.
Right.
I think it's just because I could have been there if he wasn't poor.
But I guess the simple question is Dwyer or good cause?
Well, I think it's good cause at the probate, in the juvenile court. And I think it's Dwyer, as Justice Collins said. Justice Collins, even though the Strickland case said go back to the juvenile court and ask permission for use, Justice Collins said no, that determination is best made by the criminal court judge. In this case, it would be Judge Richard Carey, who's been specially assigned in the Hampshire County case.
So in the first instance, the juvenile court uses, in your view, a good cause standard. If satisfied, it goes to the trial judge in the Superior Court or whatever court department, and the trial judge then uses Dwyer?
Yes. And it does it in a manner in which it's consistent with virtually every criminal case where the Dwyer issue and third-party records are being proffered.
But it sounds to me, actually, as if what you're calling for is not a good cause standard, but a standard that says everything that I, meaning the father, had access to at the care and protection proceeding, his attorney should have access to in the criminal trial.
If I was the same, I would have access. I mean, we have a duality here.
So are you asking us for a good cause standard, or are you saying that there's good cause when essentially your client already had access to all of that and simply wants to be able to have his attorney have access to it?
I think it's the latter, Your Honor. I think it's that. The fact that Mr. Conley was sitting in that courtroom and heard all the evidence, heard all the discussions, saw all the exhibits, and I see my time is up, but that also impacts directly on my view relative to the Fifth Amendment privilege that was waived by the mother, as well as the waiver of the psychotherapist privilege.
If we could let's go to the psychotherapist privilege. Would it be your view that, I mean, of course, your client heard it. Would it be your view that you could use that testimony at trial without getting the Superior Court judge's approval?
No. My view would be that I would, again, have access to it because of my clients sitting in the courtroom, but again, use because it's presumptively privileged. I would argue to the Superior Court judge that privilege was waived, and I would further show that this portion and this portion of that particular testimony bears directly on issues that are before that the jury is going to have to decide in the criminal case, and therefore I would want either to call that therapist or to use that recorded testimony.
Excuse me, one more question. Does your assistant counsel, who was at the care and protection, does he have to seek any further legal proceedings in order to be released from his obligation to maintain confidentiality in order to talk to you? Are there other steps that need to be taken?
I think there just needs to be clarity that, as I looked at the uniform rules of impoundment, and I think the court made reference to it when it came on when we began the discussion this morning, it's impounded from the general public. In my view, Attorney Tripp and I are not the general public. We are officers of the court representing the same client and the dissemination. I can just share with you that when I've had conversations with Attorney Tripp, he feels that there's been some ambiguity in Judge Collins's orders that makes him anxious about how far he could go. So I would like it to be quite clear that he's not the general public, I'm not the general public, and that he could release that information.
But if the same standard applies, he wouldn't be in that position, right? If Strickland applies to both stages of this, a good cause standard applies to both stages, the lawyers, regardless if it was you starting out as DCF counsel or him continuing as criminal counsel, the same standard for access would apply, wouldn't it, all the way through? And then we'd only be dealing with use, and you're saying use would be governed by the ordinary rules of evidence and...
I think use is
But isn't that right? If you've got these multiple standards, you create this kind of havoc. But if Strickland is the continuous standard, you don't have these kinds of problems you're describing.
Strickland was clear. Anecdotally, when I received an order from the juvenile court reminding me that there was an impoundment order, I needed no such reminder, but that if I was going to file a motion, as I did in June, I needed to follow the Strickland protocol. You go online on Lexis or Westlaw, you can't get it because it's impounded. So I had to go to the juvenile court and ask, since the court had indicated that I needed to follow that protocol, I needed to get it that way. And again, I don't think there was any violation of any impoundment because I'm not the general public. I looked at the Strickland protocol, followed it, and made my argument to Judge Collins, which he allowed.
All right, thank you.
Thank you very much, Your Honor.
Mr. Greenbaum, good morning.
Good morning, Your Honor's Assistant District Attorney Stephen Greenbaum for the Commonwealth. I want to address one small point that I don't think has been raised in anyone's brief and may not need to be raised in terms of the burden and the judge's good cause determination. I know we disagree as to who should have the burden of proof, but the standard of proof, I would suggest the Commonwealth is assuming that standard of proof is preponderance of evidence. I know in the judge's order he said, indeed, I find by clear and convincing evidence that there is good cause. I think that is the standard he uses for making the decision about parental custody, but I don't think there's any reason to believe that the standard of proof in making that determination is anything other than preponderance of evidence.
In impoundment cases, isn't good cause just good cause? Is there, I don't recall.
Oh, maybe I'm overthinking it. Perhaps you're correct.
Can you address the privilege issue? Because in the normal course, the Commonwealth doesn't have the right to psychotherapist records absent an assertion of criminal responsibility, diminished capacity. Here, there was testimony and an assertion, testimony in regards to the CMP. So how does that give the Commonwealth the ability to discover those records?
Well, the Commonwealth, if I can backtrack, and then I'll get back to answering your question.
I hope so.
Yeah, and you'll have to remind me if I don't. The Commonwealth's showing here was, and I think the difficulty, there is an analog to Dwyer-Lampron, but the overall, all the Commonwealth could do here was say, we were part of a joint investigation, as is required under the statutes, with DCF into the criminal charges, the abuse and neglect and harm caused to the child in this case. We are aware that the principal ground, there may have been other grounds, but the principal ground that the petition to terminate parental custody was based upon that conduct for which the criminal charges are there. Therefore, we go to the court and say, that's our showing of relevance. And to the extent there's an analog with Dwyer, and I don't suggest by any means that the court is in fact a third party as under Rule 17, but to the extent there's an analog, the third party, the holder of these records, which is the trial records, is the court. And what we can show about the entire body of these records is, well, we know one of the main issues that you addressed, you third party of the court, was whether or not the parents, and in this case the mother more particularly, was responsible, caused this harm.
That takes you out of the fishing expedition, right? Mm-hmm. We know there's a reason
So-
you want this stuff.
To that extent, then we're saying, well, that entire body of records, we know, at least we apparently know that the therapist, the mother called her therapist to defend her position regarding whether or not she was a fit parent. We assume that it likely is relevant to whether or not she was responsible for the harm caused to the child. That's as much as we can show. So the issue isn't,
That's a separate question, though, right? I mean,
Right. I guess he's going to get to mine.
I'm getting to you. I don't think, yeah. I guess you refer, he was first.
Still have Justice Gaziano's
Yes,
question.
so criminal responsibility wasn't an issue there. If there's reason to believe, we don't, I would agree, we don't know what the therapist testified about too, but if the issue was whether or not, one of the issues was whether or not the mother caused harm to the child or was involved, had some responsibility for the harm here, then there's reason to believe his testimony touched upon that and might be relevant. And what happens in the typical Dwyer situation, where there is a third party, often a therapist holder, the defendant can show, well, there's a certain set of facts here that indicates to us that these records in the possession of this therapist, this person, are likely to be relevant. You can't identify the specific part of the specific things that were there. But if you make that initial showing, then what the defense counsel gets to do is look at the entire body of records and then say, aha, here's the specific stuff. And so the Commonwealth would say, the analog is, we get to look at the trial record.
So you've sold me on relevance. Suppose there was no C&P, and you had the same situation, and you had someone accused of abuse who has psychiatric treatment, right? Mm-hmm. You wouldn't have access to
I agree.
that defendant's psychiatric history absent some type of proffer by them that they're going to raise one of the mental health defenses.
I agree.
So the question to you again is, how is this different where you get access to psychiatric records without them raising a psychiatric defense?
Our position is that as far as this care and protection hearing was, the mother waived her privilege, voluntarily introduced testimony, and we're looking at the prior recorded testimony exception here to evidence. This was testimony at a proceeding which the Commonwealth would maintain, certainly concerned some of the same issues. The mother, I would disagree about the mother's opportunity to cross. The rule on that says if you had opportunity to develop on direct, that's the same thing. So
we're
that his
separating-
testimony
Can I
would
just
be
ask a
available
quick
by that.
question?
Sure.
You're separating out records versus testimony. So you're saying the testimony you should have access to because she waived.
Certainly.
But the records, what are you saying about the records?
Well, we would like to have access
Well, I
to the
understand
records
you'd
too.
like to.
If the records were introduced as an exhibit, if they
Okay,
were
but if they're-
introduced as an exhibit, then they should be treated as same part of the likely relevance to the issues in the criminal
What
case.
if they are not introduced as an exhibit?
Well, if they're not introduced as an exhibit, then I don't think we're entitled to access to them because the mother didn't voluntarily
Okay.
waive her privilege. And in part, I think the rule on prior recorded testimony anticipates a situation like this because in order to get that, you have to have the testimony, the person you want to be unavailable, and one of the grounds for being unavailable is there's a privilege that prevents that person's testimony.
Need the prior recorded testimony, because you do have to show motive and opportunity that's similar. Why wouldn't, if the mother is the defendant, why wouldn't, as it relates to the mother's testimony, that be a statement of a party opponent? What was said at the C&P? So
We're talking to them. Oh, absolutely. Well, the Commonwealth's position.
you don't need, as it relates to the psychotherapist, put that issue aside for a moment.
Yes.
And the line that you've cut between what was admitted as an exhibit and testified to, as opposed to what was never part of the trial, because that doesn't seem like it would be available to the Commonwealth, absent what Justice Gaziano indicated. But if the mother is the defendant, the mother's testimony, you don't have to worry about the former testimony exception, because wouldn't it be a statement of a party opponent?
We agree. Yes, our main position on that, these are voluntary statements of the mother. They should be admissible as substantive evidence in our criminal case. There's no privilege to testimony given at a care and protection proceeding, and Commonwealth's position is those were voluntary statements. They're statements of a party opponent, and we should have access to them. And Justice Kafker, I know you had a question.
No, I'm still back to Justice Gaziano's. I just want to play this out a second. So the mother speaks to her psychotherapist. She gives all kinds of information there. You're getting access to, because she's waived the privilege and testified, are you getting any records that have been admitted and then they're available for use as admissions at trial? I'm just trying to understand how this is going to play out with the psychotherapist records. 'Cause if they're-
That gets complicated. Are you asking me whether statements of the mothers within the records would become available? Because I think there's a statute that addresses that.
Anything that's been admitted at trial or that she testifies to, any document, and including, I mean, JLs get introduced sometimes, right? If they're available for cross-examination at DCF?
I got to say, I'm not sure about that.
Yeah, they are. So I'm just trying to understand what the limits are on the psychotherapist stuff.
I would agree. I understand. There's a tension between saying you've got this privilege, and if the Commonwealth has access to this testimonial that went in there, then it seems like the privilege is maybe not worth so much. But part of our argument is it's not clear that the waiver to the privilege at the care and protection is limited to the care and protection now, because the purpose of the privilege for a psychotherapist isn't to protect someone from incrimination like the Fifth Amendment. The purpose is to establish and maintain and give patients a sense of trust and confidence in that therapeutic relationship. Well, once she's decided, well, I don't need that trust and confidence and whatever, I don't need that privilege, I'm done with that because it's important to me to introduce it to the proceeding. Perhaps that's a waiver for all purposes because she can't repair that lost trust and confidence, which is the purpose
So it's
behind
her
the
major
privilege.
defense of losing her child, right?
Yes.
So she's waiving it for that purpose. But it sounds like you're saying that once that happens, if it's admitted in the C&P case, it's fair game at the criminal trial, everything about it, if it could be an admission.
Right, and part of our position on that is that Commonwealth finds it difficult to recognize this notion that in a care and protection proceeding such as this, where one of the principal, if not main issue, is conduct which has been indicted as criminal conduct, that the mother gets to have, because part of her concern, there is an interest in being a parent, part of that custodial concern, that somehow that is so precious that she can say what she wants there and knowing with total immunity to its use against her in the prosecution where it might be relevant.
Well, we're running ahead of ourselves. There's a dichotomy that has to be kept in mind every moment here, which is what records the father's attorney can get, what records you can get from the juvenile court. Under impoundment restrictions or under a protective order, that's number one. So that is, as it relates to psychotherapist patient privilege, that's the first hurdle because they're presumptively privileged if you go back to the Lampron protocol. And then once those records in the hands of the attorneys pursuant to a protective order only, then you go to Judge Carey in the Superior Court, and then these very difficult questions that Justice Kafker is asking have to get worked out and argued. But you can't mush together the two, the access and the admissibility.
I agree, I understand. One of the points I did want to make to the court, or ask of the court, is it's possible for this court in addressing the limited nature of the juvenile court judge's order, which is access, to not necessarily answer the questions on privilege and have us come back here when the trial judge, if we get to a certain point where the trial judge says, well, I think the mental health records, the testimony isn't privileged or not. So I would, to the extent that on this record, this court can answer those questions about whether that waiver was limited, whether the transcript of the therapist's testimony still has subject to some privilege, will be important to expedite what's already been a lengthy process getting to trial.
You're arguing, I take it you're asking us to affirm the application of the Strickland standard,
Yes.
not the Lampron wasn't applied here. Strickland was applied here, which is a different standard. And then it's available for you. I mean, it's available, its access is provided. Then we get to the use issue, but that's governed by what standard? I'm trying to understand it.
Well, it's governed by admissibility and privilege.
So, but not Lampron, we skip the Lampron step, don't we?
Well, but the Lampron step really is related to producing the records, and the records have been produced to the court. They're available.
But meaning that Strickland was the standard, not Lampron. You're asking us to affirm that it's Strickland, right?
Yes, and our argument is if there's good cause, and the standard, but the judge, the Strickland standard isn't just there's good cause. The Strickland standard is a little more refined. Good cause, the judge should be weighing and making the good cause determination. The need for a just resolution of the criminal proceedings, is that something like fair trial, and the privacy interests at stake. Well, in weighing that balance, if the juvenile, the C&P judge is going to consider whether their access is necessary for just resolution, well, it's inherent in that notion that they're relevant to the criminal proceedings. It's inherent, I mean, which is that part of Lampron is inherent, and that it's not a fishing expedition. The other two prongs of Lampron, not otherwise available, well, we're not talking about getting them from third parties. This is how they are available. And the other one is needed in advance of trial opposed to time of trial. And again, I think those two facets of Lampron really don't apply where the records have been produced in this proceeding that covers the same issue, and that relevance and not a fishing expedition are inherent in the notion of I've got to balance whether it's relevant, means for a just resolution.
All right, thank you.
You're welcome.
Mr. Chapman? On behalf of the child?
Good morning, may it please the court. Scott Chapman on behalf of the minor child. Your Honors, the child is asking that you affirm the decision of the lower court by Judge Collins in applying the Strickland protocol and releasing these records for the limited purpose of trial preparation, not for admissibility. As the judge below indicated, he is allowing the parties to use those records for preparation. Admissibility would be determined by the criminal court judge. And in this case, he applied the uniform rules of impoundment by using Rule 7 and the standards in Rule 7 and determining that it was good cause that controls. And this judge was in the best position. He heard the evidence. He knew the documents. He heard it. He held a hearing as required by Rule 11, supported by affidavit, and made specific findings. And the child agrees that the privacy issue is very important and did indicate that issue to the lower court. But the judge in his findings indicated that he balanced that issue with the child's need for justice as the alleged victim of this crime and the child's need for permanency for her future. So based upon that, we would ask that you affirm the lower court's decision.
Do you have a position as to what standard the trial judge should then use?
The trial judge in the juvenile court, Your Honor?
No, the juvenile court uses Strickland.
Yes.
Then it goes, you say admissibility should be determined by the trial judge?
But as to, yes, and I presume that would be the Dwyer standard and the Lampron standard used by the Superior Court Justice.
All right, thank you.
Thank you, Your Honor.